Welcome to our emotionally clear briefing on a topic that touches every family. What happens when someone dies without a will? In the US, this situation is more common than you might think, and its consequences can linger like a ghost, what we call the legacy ghost. Today, we'll explore the legal, financial, and emotional aftermath of dying intestate. We'll use real-world cases and symbolic visuals to help you understand why planning matters. Let's begin by defining what it truly means to die without a will. Legally, dying intestate means passing away without a valid will in place. When this happens, your wishes for your assets, guardianship of children, or even your burial preferences are not legally documented. Instead, state laws step in to make those decisions for you. This can lead to outcomes you never intended and often leaves families confused and unprepared. The absence of a will creates a vacuum, a paperless paralysis where your voice is missing from critical decisions. When someone dies intestate, state laws known as intestacy statutes determine how assets are distributed. These laws vary from state to state, but generally follow a strict hierarchy: spouse, children, parents, siblings, and so on. The process is impersonal and can overlook unique family dynamics, such as stepchildren or unmarried partners. This legal framework, while necessary, often ignores the emotional bonds and real-life relationships that defined your life. Without a will, your estate must go through probate, a court-supervised process to settle debts and distribute assets. Probate is often slow, expensive, and emotionally draining. Legal fees, court costs, and delays can eat away at your estate's value. Families may wait months or even years for resolution, all while dealing with grief. This is the beginning of what we call the emotional freeze, where families are stuck in limbo, unable to move forward. Consider the real case of a blended family in Texas. When the father died intestate, his biological children and stepchildren entered a silent feud. State law favored the biological children, leaving the stepchildren with nothing. Years of litigation followed, draining the estate and fracturing relationships. This silent feud is a common outcome when a will is missing, and it can haunt families for generations. In another documented case, a woman's burial wishes were never honored because she died without a will. Her family members disagreed on what she would have wanted, leading to delays and emotional distress. The absence of clear instructions left her loved ones in a state of confusion, amplifying their grief. This is another form of paperless paralysis where silence leads to pain. A family in California faced frozen assets for over a year after their loved one died intestate. Bank accounts and property were locked until the court completed probate. During this time, bills went unpaid, and the family struggled financially. The emotional freeze was not just symbolic, it was a harsh reality, compounding their loss with financial stress. The legacy ghost is more than a metaphor. It represents the unresolved issues, disputes, and pain that linger when someone dies without a will. Families are left haunted by unanswered questions and unfinished business. This ghost can appear as a silent feud, paperless paralysis, or emotional freeze, each one a reminder of the importance of planning ahead. Imagine an empty chair at the family table, a powerful symbol of absence. When a loved one dies without a will, their absence is felt not just emotionally, but in every unresolved decision. The empty chair reminds us that without clear instructions, families are left to guess and argue, often leading to lasting divisions. A frozen clock symbolizes the way time seems to stop for families caught in probate. Every delay, every legal hurdle, adds to the emotional burden. The process can feel endless, with families unable to move forward until the court makes its final decision. This visual captures the emotional freeze that probate often brings. A torn family photo is a striking symbol of relationships damaged by intestacy. Disputes over inheritance can tear families apart, sometimes permanently. The lack of a will often turns grief into conflict, leaving emotional scars that last for years. This image reminds us of the human cost of not planning ahead. Intestacy laws are designed to provide a default plan for asset distribution. However, these laws are rigid and may not reflect your wishes. For example, if you have children from a previous marriage, state law may not provide for them as you intended. The law's one-size-fits-all approach can leave important people out, causing pain and confusion. Most states follow a hierarchy when distributing assets: spouse, children, parents, siblings, and then more distant relatives. If no relatives can be found, the state may claim your assets. This process can be especially harsh for unmarried partners or close friends, who are usually left out entirely. Without a will, the court decides who will care for your minor children. This decision may not align with your values or your children's needs. The process can be stressful and traumatic for surviving family members, especially if multiple relatives want custody. Planning ahead ensures your children are cared for by the people you trust most. Probate isn't just slow, it's expensive. Legal fees, court costs, and administrative expenses can consume a significant portion of your estate. In some cases, families are forced to sell cherished assets just to pay the bills. These costs reduce the legacy you leave behind and can add financial stress to an already difficult time. The probate process can take months or even years, especially if there are disputes or missing documents. During this time, families are often unable to access funds or make important decisions. The emotional toll is significant, as grief is compounded by frustration and uncertainty. This is the heart of the emotional freeze. When assets are frozen during probate, families may struggle to pay bills, maintain property, or cover funeral expenses. This financial paralysis can lead to missed payments, foreclosure, or loss of valuable assets. The emotional impact is profound, as families feel powerless to honor their loved one's legacy. The emotional freeze isn't just about legal delays, it's about the pain of unresolved grief. Families are forced to relive their loss every time a legal issue arises. The lack of closure can prevent healing, leaving emotional wounds open for years. This is why planning ahead is an act of love. Without a will, families are left without guidance. This paperless paralysis leads to confusion, arguments, and sometimes legal battles. Simple decisions like who gets the family home or how to divide personal items can become sources of conflict. The absence of clear instructions is a burden no family should have to bear. When there's no will, old resentments and hidden conflicts can surface. Siblings may argue over assets, or distant relatives may contest the estate. These silent feuds can destroy relationships and leave families divided. The emotional cost often outweighs any financial gain. Visual aids help us understand the impact of dying without a will. An empty chair, a frozen clock, and a torn photo each symbolize a different aspect of the legacy ghost. These icons remind us that the consequences of intestacy are both practical and deeply emotional. A typical probate timeline starts with the court appointment of an administrator, followed by asset inventory, debt payment, and finally distribution of assets. Each step can be delayed by missing documents, disputes, or court backlogs. The process is rarely quick or easy, and families often feel stuck in a holding pattern. Unmarried partners, close friends, and stepchildren are often left out of intestate succession. State laws prioritize blood relatives, which may not reflect your true wishes. This exclusion can cause pain and resentment, especially in modern families with complex relationships. If no legal heirs can be found, the state may claim your assets through a process called escheat. This outcome is rare, but it underscores the importance of having a will. Without one, your life's work could end up in government hands rather than benefiting those you care about. In a well-documented case, a man's retirement account went unclaimed for years because no one knew it existed. Without a will, there was no record of his assets, and the funds eventually reverted to the state. This is a classic example of paperless paralysis, where lack of documentation leads to loss. When there's no will, the court appoints an administrator to manage the estate. This person may not know your wishes or understand your family's needs. The court's involvement adds complexity and can increase costs, making the process even more challenging for grieving families. Even small personal items can become sources of conflict when there's no will. Family members may argue over jewelry, heirlooms, or sentimental possessions. These disputes can escalate quickly, turning grief into anger and resentment. Litigation over an estate can be emotionally and financially draining. Families may spend years in court, with relationships suffering as a result. The cost of fighting often outweighs the value of the assets in dispute, leaving everyone worse off. Creating a will is an act of care for your loved ones. It provides clear instructions, reduces conflict, and ensures your wishes are honored. Planning ahead can spare your family the pain of paperless paralysis, silent feuds, and emotional freeze. It's a gift of clarity and peace of mind. Many people believe they don't need a will if they don't have significant assets, or that their family will know what to do. In reality, even modest estates can cause disputes, and state laws may not reflect your intentions. A will is important for everyone, regardless of wealth. Starting your estate plan doesn't have to be overwhelming. Begin by listing your assets, considering your family's needs, and thinking about your wishes for guardianship and distribution. Consulting a qualified attorney can help you navigate the process and avoid common pitfalls. Life changes, marriage, divorce, new children, or major purchases should prompt you to update your will. Keeping your documents current ensures your wishes are always clear and legally valid. Regular reviews can prevent future disputes and protect your legacy. Talking to your family about your wishes can prevent misunderstandings and conflict. Open communication helps ensure everyone is on the same page and reduces the risk of silent feuds. It's a difficult conversation, but one that can bring peace and clarity. A will is only useful if it can be found. Store your documents in a safe, accessible place and let trusted family members know where to find them. Consider using a safe deposit box or a secure digital storage service for added protection. In addition to a will, consider preparing other important documents, such as a power of attorney, healthcare directive, and beneficiary designations. These documents provide guidance if you become incapacitated and ensure your wishes are respected in all circumstances. While online templates can be helpful, professional legal advice is invaluable. An attorney can help you navigate complex family situations, state laws, and tax issues. Investing in expert guidance can save your family time, money, and heartache in the long run. This video is for educational purposes only and does not constitute legal advice. Every family situation is unique, and laws vary by state. For personalized guidance, consult a qualified attorney in your area. Dying without a will leaves your family vulnerable to legal, financial, and emotional challenges. The legacy ghost, paperless paralysis, silent feud, and emotional freeze are all avoidable with proper planning. Take control of your legacy and spare your loved ones unnecessary pain. Let's revisit the symbols we've used: the empty chair for absence, the frozen clock for delay, and the torn photo for conflict. Each one represents a real consequence of dying intestate. These images serve as a powerful reminder of why planning matters. Creating a will is about more than distributing assets. It's about giving your family peace of mind. Clear instructions, prevent disputes, reduce stress, and allow loved ones to focus on healing. Your legacy should be one of clarity, not confusion. If you haven't started your estate plan, now is the time. Gather your documents, think about your wishes, and reach out for professional help if needed. Taking the first step is the most important part of protecting your legacy. There are many resources available to help you understand estate planning, from legal aid organizations to online guides. Take advantage of these tools to educate yourself and make informed decisions for your family's future. Estate planning can feel overwhelming, but you don't have to do it alone. With the right information and support, you can create a plan that protects your loved ones and honors your wishes. Remember, every step you take brings you closer to peace of mind. Don't leave behind a legacy ghost. Leave behind clarity, love, and peace of mind for your family. Your actions today can spare your loved ones years of pain and confusion. Take control of your legacy and ensure your wishes are honored. Thank you for joining us for this emotionally clear briefing on law, legacy, and peace of mind. Subscribe for more insights and guidance on protecting your family's future. Don't leave behind a ghost, leave behind clarity.